5 seconds to go. Start. The noticee can object to the same, and this objection has to be considered by the adjudicating authority for forming an opinion to proceed further with the show cause notice would require giving some meaning to it, comma, otherwise it would be rendered otois. Stop. Para. In T. Tocano Supra, cited by Mr. Luthra, comma, this court, relying upon its decision in Natwar Singh Supra, held, para. The submission of Mr. C. U. Singh, comma, learned senior counsel is that only those materials which are relied upon should be disclosed to the first respondent. Stop. Regulation 10, comma, as we have noted earlier, comma, stipulates that the satisfaction of the board whether there has been a violation of the regulations has to be arrived at, para. After considering the report of the investigating authority referred to in Regulation 9, comma, after giving a reasonable opportunity of hearing to the person concerned, stop, para. Once the subordinate legislation mandates that the investigating authority's report is an essential ingredient for the board to arrive at the satisfaction, comma, it requires due disclosure. Stop, para. The above extracts indicate that the findings of the investigation report are relevant for the board to arrive at the satisfaction on whether the regulations have been violated. Stop. Even if it is assumed that the report is an departmental communication, comma, as held in Krishna Chandra Tandon Supra, comma, there is a duty to disclose such report if it is relevant for the satisfaction of the enforcement authority for the determination of the alleged violation. Stop, para. As held by this court in T. Tacano Supra, comma, it would be fundamentally contrary to the principles of natural justice if the relevant material were not disclosed to the noticee. Stop, para. In T. Tacano Supra, this court approved and followed the law laid down in Natwar Singh Supra and reiterated that the adjudicating authority had the duty to disclose the materials that had been relied upon during the stage of adjudication. Stop. It is also true that the adjudicating authority cannot exercise unfettered discretion to redact documents necessary for the noticee to defend his case. Stop, para. The respondent SEBI has, comma, in this case clearly stated that the documents specified, comma, namely, comma, index of bank statements, comma, calendar of evidence oral consisting of emails, letters, hard copies, comma, calendar of evidence documentary consisting of emails, letters, hard copies, comma, calendar of evidence documentary consisting of soft copies of emails, communications, bank statements, and certain supporting documents in CDs are confidential. Stop. Mr. Luthra submitted that the petitioner has been able to show that withholding of documents containing exculpatory material would adversely affect the defense of the petitioner. Stop, para. Mr. Chandar Uday Singh, comma, learned senior counsel appearing on behalf of the respondent SEBI, submitted that SEBI had conducted an investigation in the matter of Religare Enterprises Limited and various related entities for alleged violation of the provision of SEBI Act and or SEBI PFUTP regulations, comma, during the period between 1st April 2011 to 31st March 2018. Stop, para. Mr. Singh submitted that MSA Probe Consulting was appointed forensic auditor on 10th May 2018 to examine alleged diversion of funds from REL and or its subsidiaries for the benefit of the promoter promoters and or connected entities. Stop.